Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. Now, remember, you know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. So it is Tuesday night, which means it is our Tuesday night live program. We had a little bit of a stretch there a couple of weeks ago where we didn't do it because of some travel restrictions that I had to take care of, and I was in trial. And then on top of that, I just wasn't feeling very good the one night, like had something bad. But anyway, we're over it. So thanks for joining us. Now, we have a big show planned for the next hour. All right. A lot of stuff going on. Obviously, Luigi Mangione indicted in New York, basically alleging an act of terrorism to make it a capital case there in New York. We'll go through the indictment. We talked about Brian Kohberger the other day. You know, did he confess? I know some people are saying what's interesting is that, you know, what's reported, but it didn't make it into any police reports. I think that was funny. Not funny, haha. Funny, interesting that it didn't make it into police reports. But clearly, we can talk about the Brian Kohberger case. They are concerned about the DNA. Now, a lot of people are like, oh, he's so innocent. How could you? What do you have to worry about? If DNA could have been planted. And my first thought is prove it. You got to prove it, right? So we give you the analysis from a criminal defense attorney. And I love the comments where people are like, is this guy a defense attorney? Oh my gosh, he sounds like a prosecutor. Well, sometimes you got to think like a prosecutor to see where they're coming from. And you have to look at it from the prosecutor to realize what is the problem with your case. Because if it was a good case for the defense, oftentimes it wouldn't be charged. The case would have been dismissed. So clearly there's something, right, that's worrying the prosecutors in the Brian Kohberger case. So we can talk about that. And I think it can be summed up in three little letters: DNA. Big problem. And then we got the Sheriff Stein case we can also talk about as well. Ex-Sheriff Mickey Stein, because obviously, once again, you can't go shooting people unless you have legal permission and justification to do so. And if you don't have that, guess what? That's a problem. That's called murder, first or second degree murder. So big issue, something you got to think about. All right. So let's give it a couple more minutes here while people are logging in. And for some reason, my monitor over here just kicked me out. I'm not sure why that is, but anyway, we will fix that. And hold on one second. I'm not sure why that is happening that way. Let's try to reload that because I can't read the comments if I can't see the comments. Anyway, we'll come back to that. So for anyone who's joining us for the first time, my name is Scott Reich. This is Crime Talk. I am a practicing criminal defense attorney. January, just a few weeks away, we'll be starting our 30th year in as a lawyer doing criminal defense work, and 25 years will be the start of my 25th year having my own law firm representing lots and lots of people accused of lots and lots of crimes over the years. So basically, if you can think about it, no matter how bad it is, we've handled it. We've done that case. All right. So it's when I tell you how, you know, the way things are working in the legal system, both, you know, behind the scenes on the prosecution and the defense side, I'm telling you that because I've seen it, I've done it, and it comes from experience. I'm not just, you know, there's a lot of people out there. Everybody's a legal expert. And I always find it funny, all the experts that haven't been in a courtroom in decades, if they've ever done it at all, let alone, I think in the last 3 weeks, I've tried 2 cases, one in federal court, one in state court. And I was supposed to do one last week, but I was able to resolve it because sometimes you got to know when to fold them, particularly when they give you a sweetheart deal that you cannot do better than if you were to win a trial. So like I said, it is a type of situation where I am speaking from experience, ladies and gentlemen. And like I said, we actually do the cases that everybody talks about, not just talk about them. All right. I think I was looking up today between myself and another attorney in here. We have, I don't know, I think we got 6 active homicide cases going on, not to mention all the other stuff that we got going on. So yeah, it's just been, anyway, we'll figure it out. All right. So let's move on. We got enough people. For some reason, everything, it kicked me out of my monitor over here, but now we're coming back. We can see the comments. So there you go. Fake it till you make it, I guess, right? We're able to fake it till I could see what else was going on. So let me click on this so I don't get any feedback, just in case. Let's talk about Luigi Mangione. Can you come up with a better name? I just feel like I want to go get some Italian food and play some Mario Brothers. I don't know. Luigi Mangione. Grand jury returned an indictment. An indictment, pretty straightforward. The grand jury in the county of New York, by this indictment, accuses the defendant of the crime of murder in the first degree in violation of penal law 125.27 1A X, I, and B, committed as follows. The defendant in the county of New York on or about December 4th, 2024. And remember, when they say the defendant, they have to prove that it was Luigi Mangione, not somebody that looked like him, not someone using his identification, not someone wearing a jacket that looks just like him, but it was actually the Luigi Mangione. All right. And this occurred on or about December 4th, 2024, being more than 18 years of old at the time of the commission of the crime, with the intent to cause the death of another person, cause the death of Brian Thompson, and said person was killed in furtherance of an act of terrorism involving a violent act and act dangerous to human life that were in violation of the criminal laws of this state and were intended to intimidate or coerce a civilian population, influence the policies of a unit of government by intimidation or coercion, and affecting the conduct of a unit of government by murder, assassination, or kidnapping. Okay. Well, before we analyze that and come back and realize why Alvin Bragg is probably one of the worst district attorneys in the United States of these great Americas, let's go to count 2, second count. And the grand jury aforesaid by this indictment further accuses the defendant of the crime of murder in the second degree as a crime of terrorism. The defendant in the county of New York on or about December 4th, 2024, with intent to intimidate or coerce a civilian population, influence the policy of a unit of government by intimidation or coercion, and affect the conduct of a unit of government by murder, assassination, or kidnapping, committed a specified offense of murder in the second degree, in that the defendant with the death to cause another person caused the death of Brian Thompson. Count 3, as the grand jury aforesaid, by this indictment, further accused the defendant of the crime of murder in the second degree in violation of penal law, committed as follows: that the defendant in the county of New York on or about December 4th, 2024, with the intent to cause the death of another person, caused the death of Brian Thompson. Fourth, the grand jury aforesaid by this indictment further accused the defendant of the crime of criminal possession of a weapon in the second degree in violation of penal law 26503 1B and armed felony, committed as follows: the defendant in the county of New York on or about December 4th, 2024, possessed a loaded firearm with the intent to use the same unlawfully against another person. Count 5, and the grand jury aforesaid with the indictment further accused the defendant of the crime of criminal possession of a weapon in the second degree in violation of 265.03 of the penal law and armed felony, committed as follows: the defendant in the county of New York on or about December 4th, 2024, possessed a loaded firearm, said possession not being in defendant's home or place of business. Count 6, the grand jury aforesaid by this indictment further accused the defendant of the crime of criminal possession of a weapon in the third degree in violation of penal law 265.027, committed as follows: the defendant in the county of New York on or about December 4th, 2024, possessed an assault weapon. Seventh count in the said the grand jury aforesaid by this indictment further accuses the defendant of the crime of criminal possession of a weapon in the third degree in violation of 265.02. Committed as follows: the defendant in the county of New York on or about December 4th, 2024, possessed a firearm silencer. Count 8. And the grand jury aforesaid by the indictment further accuses the defendant of the crime criminal possession of a weapon in the third degree. The defendant in the county of New York on or about December 4th possessed a large capacity ammunition feeding device, to wit, a Glock magazine. Count 9, the grand jury aforesaid in the indictment further accuses the defendant of criminal possession of a weapon in the third degree. As follows: the defendant in the county of New York possessed a large capacity ammunition feeding device, to wit, a Magpul magazine. Actually, Magpul magazines are very nice. If you're going to get one, you might as well get the good one, right? Glock, okay. Anyway, 10th count, and the grand jury aforesaid by indictment further accuses the defendant of the crime of criminal possession of a weapon in the fourth degree in violation of Penal Law 265.01, paragraph 9, committed the following: the defendant in the county of New York on about December 4th, not being licensed as a gunsmith or a dealer in firearms pursuant to Penal Law section 400.00, and knowing that it was a shotgun knowing that it was a ghost gun, possessed a ghost gun. Count 11. And the grand jury, as aforesaid by the indictment, further accuses the defendant of the crime of criminal possession of a forged instrument in the second degree in violation of Penal Law 170.25, as follows: that the defendant in the county of New York on or about November 24th, 2024, knowing the instrument to be forged and with intent to defraud, deceive, and injure another, uttered and possessed a forged instrument, the same being and purporting to be and calculated to become and to represent, if completed, a written instrument officially issued and created by a public office, public servant, and government instrumentality, to wit, the New Jersey driver's license, signed by Alvin Bragg. Then they give a little summary page of the charges against Luigi Mangione. All right. So let's go back up. Counts 1 and 2. First degree murder, second degree murder by act of terrorism. All right. Seems like a little bit of overkill. I get it. You got to charge it. But I think I would have held that a little closer. But maybe the prosecutors have something that we don't know about as of yet. But it says, like I said, the defendant. They have to prove that it was the defendant, that he did this, not somebody who looked like him, not someone using the identical jacket, right? So all the Italian guys are going to show up that have the thick, good-looking guys are going to show up with the big, thick eyebrows and sit in the courtroom. So when the police say, do you see the person in here that was on that street corner that day? Well, they really can't, because he had a hood on and a mask on, etc. So, and they say, do you see that person here in the courtroom? Maybe everyone will be like, oh, was it that guy? I've had that happen before. Had it happen not that long ago in the federal trial. One of the witnesses got up a special agent and actually said, or an officer said, yeah, that's the guy. And he pointed to the marshal in the courtroom, the U.S. Marshal. No. My client's over here. He's over here, guy. It could happen. Not that it's going to come down to DNA, all that kind of good stuff. They're going to prove identity through DNA and other things that they obviously are going to come up with, being able to track allegedly Luigi Mangione crime. Now, like I said, seems like a little bit of an overkill. Person is 18 years of age, commissioned the crime with the intent to cause the death of another person. I get that. The person was killed in furtherance of an act of terrorism. Not exactly what you think of terrorism, is it now? But hey, it's New York. I get it. They're a little sensitive. They should be, right? But listen to the definition. An act of terrorism involving a violent act. Well, okay, certainly it's a violent act, right? Gunning somebody down on the street corner, and acts dangerous to human life that were in violation of the criminal laws of the state. Yeah, I guess so, right? There's laws. You can't shoot people, can't kill people, don't have ghost guns, don't have silencers. I get all that. And were intended to intimidate or coerce a civilian population influence the policies of a unit of government by intimidation or coercion, and affect the conduct of a unit of government by murder, assassination, or kidnapping. If I was the attorney, would first be filing a bill of particulars as it relates to counts 1 and 2, murder in the first degree and second degree as an act of terrorism, saying, please identify the civilian population that was intended to be intimidated or coerced, the civilian population, or the policies of the unit of government by intimidation or coercion affect the conduct of a unit. Now, I get it if you fly a plane into the Twin Towers and you're saying, oh, we did it. We don't like the U.S. government or their policies. I get it. This seems like a stretch to me, ladies and gentlemen. Obviously, Luigi Mangione is given the presumption of innocence, as he should, unless and until a jury finds him guilty beyond a reasonable doubt, or he pleads guilty in a court of law. So count 2, same thing, murder in second degree by terrorism. No, come on. That is political theatrics. All right. And, I will bet somebody a big steak dinner that there will be a resolution of this case. There will be a resolution of this case, and it will not include count 1 or 2 of this indictment. Frank, mark that down. Mark my words. Okay. Put a little sticky note somewhere. Scott said this case is going to resolve at some point without counts 1 or 2. What is there going to be a plea of guilty to at some point? Just now, do I know? Do I have a direct line to Luigi Mangione or his high-powered attorney who's been a prosecutor for all her career and only 3 years as a criminal defense attorney? Maybe 3 years, 4 years. No, but she can look at it and say, oh, come on, this is ridiculous. Alvin Bragg, the worst DA in America. Total overkill. But that's what DAs do. They overcharge their cases, right? To say, oh my God, this could be the death penalty. Oh my God, this is terrible, right? Yeah, no. Okay, third count, that's it. The defendant in the county of New York on about December 4th, 2024, with the intent to cause the death of another person, caused the death of Brian Thompson. Clearly, one could argue that is the most relevant and applicable charge. And you can always say, you can always have a defense. I mean, let's face it, ladies and gentlemen, let's start thinking like a defense lawyer, right? It was not my intent to kill him. I only attempted to shoot him, maybe shoot him in the leg. It's not my fault that I'm a bad shot, but that's kind of the natural result. But you say, I attempted to do it. It was an attempted murder gone bad. That's usually what these are. You got to come up with something, right? If they prove identity that is in fact him, I still think there'll be no trial on this. There'll be a plea to count 3, and maybe a sundry of weapons charges here, and he'll go to prison for 60 years. That's my anticipated. That is my anticipated resolution of this case. So jot this down: 60 years, count 3, sundry of all these weapon charges. Now, frankly, you're surprised that anybody could have got a gun into New York, probably because it was a ghost gun, right? Manufactured through 3D printing and things of that nature. Probably why it jammed so many times. But, guns are super illegal in the state of New York. So I'm surprised they even got one in there, let alone, having the high capacity magazine, a Glock and a Magpul magazine into the ghost gun. Oh my God. And then to have a silencer. And, that's the worst of Mr. Mangione's troubles here, but that's something his attorney will have to figure out what she's going to do. And obviously the criminal possession of a forged instrument, apparently what he gave at the hostel. Yeah, nobody's going to really care about that. Okay, so to recap, count 1 and 2, total overkill. All right, an act of terrorism. Yeah, no, I don't think so. And even trying to be as generous as possible I can to the prosecution. Like I said, total overkill. That's why Alvin Bragg is the worst district attorney in the United States. If I haven't mentioned that before, if you don't really know how I feel about him, he's the worst district attorney in the United States, possibly the world, right? Alleging that Mangione killed in furtherance of an act of terrorism involving a violent act and dangerous acts to human life that were in violation of the criminal laws of this state and were intended to intimidate or coerce a civilian population, influence the policies of a unit of government by intimidation or coercion, and affect the conduct of a unit of government by murder, assassination, or kidnapping. File the bill of particulars. Say, coercion? Who was coerced by the civilian civilian population? And what policies were intended to be influenced by a unit of government? Which unit of government? And define intimidation, coercion, and affect the conduct of a unit of government. Tell me which government unit was intimidation or coerced and affect the conduct of that unit of government. File a motion for a bill of particulars right away. I mean, have I mentioned that Alvin Bragg is one of the worst district attorneys in the United States? Okay. Overcharges crap like this. Just keep it simple. He was trying to get the headlines. Oh, this is terrible. This is a egregious act. I agree. Whomever did this, and like I said, we'll give old Luigi the benefit of the doubt, the presumption of innocence. But if he is the one that's found to have done this, it's pretty bold to build a ghost gun, find this guy, this Mr. Thompson guy, who's head of United Healthcare, one of the largest and perhaps most profitable, insurance companies in the United States, and shoot him, first thing in the morning. I think it was 6 a.m., something like that on December 4th. That's bold. That's bold. That's daring, clearly planned after intimidate, clearly thinking about it, but that's what it is in violation of penal code with the intent to cause the death of another person, cause the death of Brian Thompson. Right? Straightforward. I don't know. That's what the count that should have been there. Terrorism? Ridiculous. I think that is truly ridiculous. The gun stuff, like I said, it is what it is. Even his writings, if you say, this guy is a bad guy, his company makes too much, they denied policies for people. Let's face it, insurance companies are evil. You're not going to change insurance companies, right? Insurance companies aren't going to change. What the hell is the government supposed to do? Oh my God. The United Healthcare CEO was shot in the street. We must change our policies. They're not going to do that. Come on. I'm serious. I would love to have been a grand juror in this particular case and see what they were relying upon. If somebody has something else, thinks there's something there, let me know. But I just don't see how this is an act of terrorism, even under the definitions here in the indictment of New York. Identify that. And that's the first thing Mangione's attorney is going to do, is going to go in there and say, oh my God, Alvin, get for real. Even if you could prove that, it's ridiculous, but you're not going to be able to prove it. The best you can do is count 3. If at trial, if all the planets align, you don't get some of those 40% of the people that think that the death of Brian Thompson was okay or justified. Give us a third count or even something less, some sort of heat of passion, because I'm going to give you a bunch of mitigation about my guy's mental health, and he was not in a good place at the time, and blah, 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 blah. And she's going to say, Alvin, Al, we go way back. You can't prove this. Give me something less. Give me like a heat of passion or something along those lines. And did I mention his family's rich? yeah, his family's rich, and we're going to drag you over glass if you get a conviction, and then we're going to appeal it for years, and you're going to have another embarrassment in the headlines. So why don't you just give us what we want, and we can go over that. Tanya, Scotty incited people over social media. Yeah, well, incited, he didn't go out and say, go kill people, right? The here is that he coerced a civilian population. He intended to intimidate or coerce a civilian population. I mean, I guess the victims of this that Alvin Bragg wants to bring in, maybe healthcare workers, people, not healthcare workers, but insurance workers. That's, I guess, the civilian population. And what government unit was affected by intimidation or anything along those lines? I don't know. But the victims here apparently are the healthcare industry. Good for you, Alvin Bragg, looking out for the healthcare industry. I'm sorry, not the healthcare, insurance industry. The people that deny claims all day long. Okay. And like I said, I get it. The guy, he didn't incite it. It all came up afterwards. People were like, yeah, he did it. It's not like he's out there saying, go, attack people. No, that would be incitement. Yeah. And the guy had, I think we did the thing. I don't know if we put it, I think we did a short about his outfit. The guy's wearing Hermes shoes, like a $600 jacket, a $400 backpack. Oh, did I mention his family is rich? And they apparently hired, the next big heavy hitter in New York. I'm not even going to pronounce. Let me see if I got her name here. Agnifilo, Agnifili, Agnifilo. There it is. Karen Friedman Agnifilo, and her husband Mark Agnifilo. He's the guy that represents old P. Diddy. Well, Karen, she is of counsel at the firm because she's too busy consulting for, I think, Law and Order. And I think she's consulting for CNN and things like that. So, yeah, it'd be interesting to see. It's going to be interesting to see. Terrorism? I don't think so. I think, are you aware that now there's Luigi email accounts on social media? Wouldn't surprise me. I think I read something today that he has received voluminous amounts of mail at his detention center. And what's the word is they put money on his books. Yeah, Sally's true. He's going to hate his healthcare plan in prison. His dental plan will be chew on the other side. Yeah. You don't like private medicine? Private health insurance, wait till you get in there and you need something done. True story. Had a client. It's like, man, something's not right. He puts in various kites. They ignore him. We'll get around to you. You're just a prisoner. I ask, hey, something's not right. Get this guy to a doctor. After repeatedly asking for several months, they get the guy to the doctor. They're like, oh my God, your client has cancer. You need to get him to they need to take him to the hospital immediately. Okay, let's do that. Let's get him going. Well, they tried to start chemo or something at the hospital. Client somehow gets an infection. They transfer from the prison to a hospital. Now, they tried doing chemo at the prison, like in the little, like the nurse's office or something. Doesn't work so well. Gets infected, goes to there. Then one day I was like, hey, I can't find my client. Where's my client, Mr. Detention people? Oh, yeah, we had to move your guy. He's in a different state because he's got some real problems. They're giving him treatment, but, he basically almost died. And we'll see if he comes out of it. But I don't think their delay helped his situation at all. So healthcare in the prison is not going to be great. Now let's take a quick break here. Frank, I believe the dinner has arrived. So excuse us for that. We had to do that because, it's Tuesday Night Live. Obviously, we don't go home. I always let Frank choose what we're eating for dinner. Of course, I buy because I'm keeping him late from his wife and family. And of course, he just moved. So, we got to feed him. He's got to keep his strength up. Right? All right. So let's go through them. All right. We'll take your comments, but let's talk a little bit about Brian Kohberger. All right. The motion that I want to see in the Brian Kohberger matter is the motion regarding the genetic genealogy that was filed under seal. The prosecution's response was filed under seal. And that is what is going to dictate everything in the Brian Kohberger matter. Because if the court were to find that somehow this information that was put together through this genetic genealogy was obtained in violation of Mr. Kohberger's constitutional rights, everything fails. Everything is going to fail. And do I think the judge is going to grant that motion? Now, I haven't seen the motion. I haven't seen the response. I haven't heard the arguments, but hopefully we get to see them when they have the motions hearing next month. I believe we're set. I don't know. I just don't see this particular judge granting that particular issue, right? Those are not issues that trial court judges usually try to get involved with, because trial court judges, they're elected by the people. They got to stand for re-election, all that kind of good stuff. That's appellate lawyer type stuff, appellate judges type of stuff. But think about it. Do you have an expectation of privacy when you give away your stuff, or your family does? I'm not sure that you do. And don't get me wrong, I think there should be privacy in that. I would think that you would think these companies that are collecting your DNA to do all these things would say in big bold letters, we're going to sell this stuff to everybody. We're going to give it to anybody who asks that's with the government. Don't worry about it. Trust us. It'll all be okay. We won't use it for anything nefarious in any way. But I don't see how there is an expectation of privacy as it relates to that, unless there was some statutory right given. And I'm not aware of any right given, right? Think about it. It's kind of analogous now to where, let's say you are accused of a crime, and the police officers say, we want to get all of your phone records. Here's our either subpoena, administrative subpoena, or a warrant. The phone company, if they have them, are going to turn them over. And they're going to say, well, it's really our data. It's not really your data. And so, we're going to give it to you. And frankly, they're required to give it to you under various acts. I can't remember the digital one, but it's the Digital Something Act that, basically, the Facebooks and the Googles and the YouTubes of the world basically get immunity for doing what they do. But in exchange for that, you basically got to give the government everything that they want. And they do it. They comply all the time. So think about it. Genetic genealogy people are there, just minding their own business, just collecting everybody's DNA, trying to make the world more connected, figure out your genealogy so you can figure out who's there and who's not, I guess, in the family. Something scandalous, so to speak. Find out what's going on in the real family. We always wondered about cousin Joe. He seemed a little odd. There were always rumors that he just showed up one day, those kinds of things. People want to find that stuff out. Anyway, so they give it to the information. They get the information, right? They have this suspect. They think it's the car, right? And they say, hey, we have enough information. We think it's maybe related to this guy. Do you guys have any of this genealogy information as it relates to somebody in Kohberger's family? Because we'd really like to take a look at it, right? They get this partial DNA profile, but they don't know who it is because they can't put it through the CODIS system, which is the system where, if you've been convicted of a felony or you've been arrested with a felony, they take your DNA sample when you get arrested now, and it all goes into the big CODIS system. So there you go. I mean, they get it. They say, hey, we got this partial DNA. Do you have anything that kind of matches it? Well, let's take a look. They go over to the filing cabinet, figuratively speaking. Oh, here's one that's close. Oh, look, we think it's the, Kohberger family. Yeah, it's the sister, brother, aunt, uncle, whatever. So they try to create a DNA profile to match that. Say, yep, close enough. Okay. Then they go there and say, oh, we've got a match, right? Then they go back to the judge and say, Judge, hey, we, being the detectives that we are, not just data analysts or collectors of data, not like old gumshoe detectives anymore. We went to this place and we could create this DNA analysis. So now we want to get the DNA samples from Brian Kohberger so that we can compare them to our known match that was found on the K-bar knife sheath right here, right? As we know, on the button there, right there. That would make sense. Nice smooth spot where your DNA, your oils, that contain your DNA from your finger, stuck right there. When you're pushing it. Because, this one is, I don't know, 30 plus years, 35 years old, this K-bar. I got this in 1988, ladies and gentlemen, and still have it. It's live, so I can't take it out of the sheath because apparently that's too scary. Google will or YouTube will take it down. It's too scary. So anyway, knife sheath, DNA right there, right? That's it. That's the problem for Brian Kohberger. That's what I said was going to be the problem in this case all along. People are like, oh, Scott, that DNA can be planted there anytime it wants. You don't know what you're talking about, blah, 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 blah. Every single motion that the defendant's attorneys have filed all say they reference the original motion as it relates to the genetic genealogy filed under seal. We don't get a copy of that yet. That's the big one, right? Every single one of them. But let's go through these, right? Motion to suppress, memorandum in support, the Amazon account issued by the federal grand jury, right? If you go look at it, there were probably 30 subpoenas, returns, where they sent information requests out to probably every app on Brian Kohberger's phone. But something must have come back, and although they don't specifically say, regarding a purchase through Amazon. Now, like I said, they don't state in here what was done, but it says, first of all information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. Basically, they're saying there was faulty information in the warrant to get the genetic genealogy. They used the genetic genealogy to get all these other warrants to show him as a suspect. It was obtained illegally. These are all fruit of the poisonous tree. They need to go away. If it's not fruit of the poisonous tree, there are misrepresentations as it relates to this. Basically saying that they need a Franks hearing because there was false and misleading information, and the warrants can't stand on their own if you excise out that particular information. But there was something purchased at Amazon that the defense wants to make go away, ladies and gentlemen. Now, I'm not going to sit here and say I know what it is. I've read the motion. I've read it a couple of times. Doesn't say. Usually when I file a motion to suppress, I say, Judge, I want this suppressed. They're basically saying everything from Amazon. I usually say specifically, I would like the information regarding the purchase of the K-bar suppressed because it was obtained illegally. That's what you're supposed to do. Kind of give some information, general information about that. Something's there that the defense doesn't like as it relates to Amazon. Then the search of Mr. Kohberger at the when he was arrested. Once again, Everything was illegal because of the illegal obtaining of evidence as it relates to genetic genealogy. AT&T, right? First warrant. What's the issue there? Ooh, could it be phone records, ladies and gentlemen? Ooh, we don't like those phone records. Those phone records tell us GPS locations or cell phone tower information where they can triangulate where he may have been during a particular time period. They want something from AT&T to go away, ladies and gentlemen. Ooh, once again, some Google stuff. Overly broad, right? The affidavit submitted in this application of the issued search warrant recklessly, intentionally omitted material information. The affidavit submitted in support of the application for the issued search warrant included information that must be excised, i.e., not truthful. All information in the affidavit was gathered because of law enforcement's unconstitutional and intentionally omitted use of investigated genetic genealogy, and thus nothing in the warrant should remain. Information gathered about Mr. Kohberger via previous invalid warrants must also be excised. The search warrants are duplicative and fail to command law enforcement to search the Google accounts. The search warrants fail to provide specific particularization of what law enforcement could search. Mr. Kohberger has a privacy interest in his Google information and email accounts protected by Article 1 and Section 17 of the Idaho Constitution and the Fourth Amendment. So the basic facts, let's see here. Let me go. Okay, the basic facts Mowry used to support the search warrants were those listed in Exhibit B, which are filed under seal, and those that have been used to support the arrest. Exhibit B to the 3 Google warrants were different versions of the arrest warrant and details about Google as a company and what it stores based upon Mowry's personal knowledge, a request for any accounts associated with Kohberger for any time period. Kohberger was observed entering CVS in Pennsylvania on December 16th of 2022, and his email account, brianchristopher1994@gmail.com, and phone number was somehow obtained by law enforcement. For Google Warrant 2, January 24th, 2023, a new email is referenced as having been found in a Google Warrant 1 data return, YEWSIR YEWSIRNEIGHM@gmail.com. Also added was a highly probability of a VPN was identified in Google return of 1/3 of 23. For Google Warrant 3, a new email, bk5781@desales.edu, is incorporated into the third warrant without any supporting explanation. See Exhibit C. Basically, what they're saying is the cops screwed up these search warrants. Now, remember, a search warrant, right? A search warrant needs to be particular. You don't get to say, hey, Google, give me anything you got on Brian Kohberger. We're not really sure what we're looking for, but we'll know it when we see it, right? Let's just take a little run down legal lane here and go to the Fourth Amendment, a great amendment, I must add. Amendment 4 of the United States Constitution, right? The Bill of Rights was just ratified on Sunday, 1791. The right of the persons to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Right? Let's go back. What do we always talk about? Why do we have the Fourth Amendment? Because the king was a thug. The king didn't like you. He would send all the king's men down to your house. He would kick open the door and say, we don't like you. The king doesn't like you. We're going to rummage around your personal effects here in your place, right? Your house, papers, and effects. We're not sure what we're looking for, but we'll think there's something in here that we can use against you because the king doesn't like you. You're a rabble rouser. You're out there saying bad things about the king. And next thing you know, you probably have a gun here that we don't like too. And on top of that, when we get done searching this place, we're going to, you're going to have to quarter the troops here and take care of all of our horses. And we're really, really hungry. Okay. And so they said, hey, we don't like what the king's doing. He's a bully and a thug, and we're not going to allow it. We're going to put restrictions on government, no matter how bad or heinous the crime may be. You can't just say, give us everything. That is a general warrant. General warrants are illegal under the Fourth Amendment, ladies and gentlemen. You must particularly describe what you're looking for. So when warrants say everything, overly broad, okay? We had a ring of cases here in the state of Colorado, and we've had, some really bad cases dismissed because there was a Supreme Court case that came out and said, hey, this is a general warrant. You can't just ask to dump everything in the person's phone into a hard drive. That is a general warrant. Don't even get me started on phone dumps. We can talk about it all night long because it is a rummage, and I'll explain in a minute briefly. But they have to be particularly describing what they are in fact looking for, ladies and gentlemen. And that's what they're saying here is you can't just send to Google, hey, we got this one, send us that information too. Send us that one too. You have to be able to relate how it is reasonably related to the crime, what you're looking for. You don't say, give us any and all emails of Brian Kohberger between the last 10 years. That is a general warrant, ladies and gentlemen. And any magistrate worth his salt should not have granted that warrant. And hopefully a judge at the district court level would have enough chutzpah, backbone, whatever, to say, that's a general warrant. And you guys know better. And I'm going to suppress that. I've seen it happen. Okay. Next, Apple accounts. Same thing. General warrant. It was obtained illegally based upon the previous information. And basically everything should, in fact, go away. All right. Search warrant for the Hyundai Elantra. They've challenged everything. Obviously, there's something in the Hyundai Elantra or the car itself that the defense doesn't like. Remember that, ladies and gentlemen, when there's a motion to suppress, you're saying, man, there's some incriminating evidence, but you guys got it illegally. Okay. And it shouldn't come in because otherwise it's going to be devastating to our case. All right. Just remember that. That is your defense, free defense legal advice of the year. Everything that they're not going to tell you anywhere else, I'm going to tell you, ladies and gentlemen. We're getting up all the secrets. Okay. The search of Mr. Kohberger's person in Pennsylvania. This is what I love, though, is now they got to fly these officers from Pennsylvania out to Idaho for the motions hearing. Trap and trace devices, right? What are trap and trace devices? That's basically where they say, hey, AT&T, we would like to get all the information on Mr. Kohberger's phone for a particular time period. And let's just say on the allegations that they say are wrong. Let's just go through it really quick. On December 23rd, 2023, Corporal Payne of the Moscow Police Department requested a warrant to search the contents of Mr. Kohberger's AT&T account for information regarding his phone's whereabouts November 12th, 2022 and November 14th, 2022, as well as messages and phone calls during that period. However, the affidavit and warrant went beyond that range. After the warrant was granted, law enforcement received information from AT&T. The new information is included in the affidavit for a new warrant sought for both accounts' information, as well as pen, trap, and Mr. Kohberger's phone. The exhibit was like the previous warrant signed by Corporal Payne. The basic facts of Corporal Payne's that he used to support the search warrant were essentially the same, but the following added. Cell tower records did not show Mr. Kohberger was in Moscow at the time of the murder. In law enforcement's experience, however, people committing crime typically turn off their phones. The new information received from the previous warrant, according to FBI special agents that specialize in the analysis of historical cell site location information showed that on November 13th, 2022, at approximately 2:42 a.m., Mr. Kohberger's phone was utilizing cellular resources that provide coverage to his apartment in Pullman, Washington. They support the idea that he left his apartment and went south. They supported the phone being off. They support at 4:48 that the phone is south of Moscow, Idaho, near Blaine, Idaho. The phone utilizes resources that make their way back to Pullman, coinciding with a white Elantra seen on some surveillance there. A similar data occurs at 9 a.m. with a trip to Moscow and return at 9:32 a.m. Then they go on that he has a privacy interest in his AT&T account information protected by the Idaho Constitution and the Fourth Amendment of the United States Constitution. And this is kind of interesting, but let's just go through it really quick. I think it's interesting. Both the Fourth Amendment and Article 17, Section 17 protect people's interest in privacy. A person challenging a warrant has the burden of showing that he or she has a legitimate expectation of privacy in the item or place to be served. And then they cite to Rawlings v. Kentucky, United States Supreme Court case, and State v. Cohen. That involves a two-party inquiry. Did the person have a subjective expectation of privacy in the object of the challenge search? And is society willing to recognize that expectation as reasonable? And once again, they cite a United States Supreme Court case, California v. Ciraleo, 1986 case. And then they state the Donato. Here at stake are records of a telephone account. The records the state seeks include is identifying information of the account owner, device purchase information, email address associated with the account, call detail records, including text messages and data activity, cell site information, historical location information, cloud data, timing advance reports, and obviously the Fourth Amendment has generally refused to acknowledge a privacy interest in records held by a corporation about communications they facilitate. And they go in some case law, says every circuit to have considered this question has held that an individual has no reasonable expectation of privacy in phone service provider records of the phone number that he has dialed or from which he has received calls. However, in Carpenter v. U.S., a 2018 United States Supreme Court case, the Supreme Court declined to extend the third-party doctrine to historical cell site records and cell site location information. In this matter, Corporal Payne specified in his request that the purpose for gathering the information from AT&T records was to aid in determining the location of the 8458 phone and the white Elantra in an effort to determine whether the white Elantra is the same vehicle identified in the surveillance videos. Now, pursuant to Carpenter, to the extent that information was being gathered for the movements of the vehicle, Mr. Kohberger has a privacy right protected by both the Fourth Amendment and Article 1 of Section 17. In the wake of Carpenter and the court's recognition of the abundant records maintained on everyone in modern society, it is questionable whether the third-party doctrine is still good law. However, this court need not consider whether the Fourth Amendment needs updating because Idaho has already recognized an expectation of privacy of whom we dial and the content of the text messages we send. Therefore, to collect the records law enforcement requested in this matter, it had to have had a valid warrant. Then they say the affidavit submitted in support of the application for the issued search warrant was recklessly or intentionally omitted material information, relies on information gained in violation of the Constitution, and fails to provide probable cause. Then cites something, the Fourth Amendment states that it's quite unambiguous that no warrant shall issue but upon probable cause and supported by affirmation, and particularly describing the place to be searched and the persons or the things to be seized. Probable cause exists when given all the circumstances set forth in the affidavit. There is a fair probability that contraband or evidence of the crime will be found in that particular place. For it to be valid, the judge issuing the warrant must rely upon the affidavit or the affidavit sworn to before the judge or by testimony under oath and recorded that established the grounds for issuing the warrant. Any discrepancies between items for which there was probable cause and their description in the search warrant requires suppression. It's clear that the issuing magistrate himself, if he is to fulfill the constitutionally mandated function of interposing an independent intelligence between the law enforcement officer and the citizen, he must actually and in fact draw the inference from the evidence presented to him. It is for this reason that the courts have insisted that the full facts from which inferences might be drawn and information necessary to determine their reliability be placed before the issuing magistrate. So they got to put in all the good, the bad, and the ugly if it doesn't help their case. They got to put it in there so the judge can decide that. Anyway, it goes on basically saying there's a Franks hearing. It was all obtained illegally, false information, et cetera, et cetera, et cetera. But obviously there's something in those records the defense doesn't want to come in. If they got the records and there was no big deal, nothing alleged to be incriminating, the defense would move on. They simply would not do it. And then we have the search of Mr. Kohberger's person. When he got arrested, they took photographs and things of that nature. And of course, I think the big one is the statements allegedly made, whether post Miranda at all. But of course, they redacted that particular one. They was basically saying that he was zip tied, etc. It says all statements made at the police station were post Miranda. Information in the media writes right after the arrest and attributable to law enforcement report that Mr. Kohberger blank. Such a statement is not in the police report or an audio-visual recording that can be found in discovery. If it's in a statement the state will seek to attribute to him at trial, it should be suppressed as a non-Mirandized statement. So it gets tricky, right? Of course, there's that big blank report that Mr. Kohberger redacted. Did he say, I got you? Did he say, oh, did you arrest somebody else? Have you arrested anybody else? I'm sure, I don't think, have you arrested anybody else would fit in that little spot. We'll have to wait and see, ladies and gentlemen. But clearly, it's a statement that hurts the defense. So that is the lesson for this evening. When there's a motion to suppress, it's because, one, you claim that it is evidence that you have an interest in, that you have standing to challenge, and that the evidence was obtained illegally and therefore should be suppressed because it's incriminating. You don't care about evidence that's not incriminating coming in because it doesn't prove that you did anything. So that's it. Now, of course, the government's responses were, we're the government. We did everything okay. Trust us, judge. The question is, will the new judge in the Kohberger matter trust the government? He seems pretty hard-nosed, kick stuff back. I don't think the defense is going to get a whole lot of relief on these motions. I think that if there's going to be issues, it would be as it relates to any appellate issues down the road, if there is in fact a conviction. So there we go. Let's take a look at some of the comments here. I'm sorry, Scott, I commented earlier about Kohberger, and I said I knew someone who supposedly got away with 2 killings. Clue was both were wise women. It was years apart. Who was this person, Scott? Tanya, I'm not sure. Got away with 2 killings. I don't know. I don't know. I don't see it. I don't see the answer. I don't know. You're stumping me. Tanya Smith, Peter Falk. Okay. Didn't know that. All right. Let's see. WSU officers found his car headed that direction at one of the campus cameras. I agree. That is the evidence that's out there. I don't know. I just think it's interesting, right? We've got, situation where we have, what's the word I'm looking for? We have a situation here where we have Brian Kohberger accused of a quadruple homicide. The state is seeking the death penalty. And it's DNA. And I've told you, every case you get as a defense attorney, you say, what is the worst piece of evidence that we have? How do I counter it? The bad evidence. Or how do I make it go away? I literally said, we got to make that go away. They're trying to do that. They're doing everything they can. And I know they're rolling out all the stops and they're going to do whatever they can, but they're probably preparing for trial based upon the assumption that all these motions are going to be denied. But just remember that the defense knows that this is bad. It's all bad, or they wouldn't be trying to get rid of it. Just something to think about, ladies and gentlemen. So I'm going to put this in my stack of stuff as it relates to the Brian Kohberger matter. All right. But don't worry, all you CrimeTalk aficionados, I went through and read it all so you didn't have to. Look, and that's not even the important one. The important one that I want is the genetic genealogy. We're going to see if that does it. Now, let me I always think this is funny. Now, let's jump to the Lori Vallow case really quick. Obviously, she was convicted of killing Tammy Daybell, JJ, and Ty Lee, right? She's appealed. And the public defender has been appointed to represent Lori Vallow on her appeal. And they have to do everything. They have to do the appellate issues. They have to do 35C, raise all those issues. And then there's various things that need to be done rather quickly. Anyway, this, I think, is like the fifth resetting. And the attorneys for Lori Vallow said, we need more time. We need more time. Talk about a stick it to you kind of thing. They filed a request for an extension. Be advised that the briefing in the above entitled appeal has been reset. Appellate's brief is now due on or before December 26, 2024 on a fourth extension of time. Now, I get it as a death penalty, or it's just a homicide case. It's not a death penalty case, but December 26th, ouch. Maybe somebody in the clerk's office just calculating, well, here's give them 30 days. December 26th, those attorneys are going to spend the holiday. Hopefully they get it done, or they ask for another continuance for sure. All right, ladies and gentlemen, man, time went by fast, didn't it? It sure did. Guess what? We didn't even have time to go through the callers. I guess you'll have to come back next week, or you can become a Patreon member. And I think you can sign up below in the links. I know it's like $1, and then you get to show up, you sign up, and we have a call-in number, so you can call in. We'll talk about whatever you want because it's your show, because we appreciate our patrons. We appreciate everybody that's joined us this evening. But our time is up, so we have to go. So thanks for watching. Hopefully we'll see you all at the Patreon side as well. Have a wonderful night. And remember, the Constitution matters. Even if you're accused of killing 4 people, the Constitution matters.